borrowing from a foreign shareholder often feels straightforward. There's trust between the parties, the company needs funding, and the shareholder is willing to lend. So on the surface, it can seem like a simple internal arrangement. But even when trust and shared ownership are in place, a shareholder loan is still a financial and legal transaction. And in Vietnam, it needs to be structured carefully to meet regulatory, banking, and tax requirements. In this video, we'll walk through 5 key considerations to keep in mind when borrowing from a foreign shareholder, so your funding remains compliant, enforceable, and low risk as your business grows. The first question to answer is a fundamental one. Is this funding genuinely a loan, or is it closer to a capital contribution in substance? If a shareholder provides funds without a clear repayment plan, interest terms, or a proper loan agreement, authorities may view the transaction as capital rather than debt. That distinction matters. Capital contributions are governed by investment and enterprise regulations, while loans fall under foreign exchange and loan registration rules. The tax treatment is also different. So before any funds are transferred, it's important to be clear and consistent about whether the funding is intended as a loan with repayment obligations, or as capital tied to ownership. Another common misconception is that shareholder loans are exempt from registration because they're internal. In reality, when a lender is located overseas and funds are disbursed into Vietnam, the loan is generally treated as a foreign loan under Vietnamese regulations. If the loan is long-term, or becomes long-term due to extensions or delayed repayment, registration with the relevant authorities is typically required. Without proper registration, companies may face blocked repayments, difficulties deducting interest expenses, or potential regulatory penalties. That's why registration requirements should always be checked before funds are received, not after issues arise. Even when borrowing from your own shareholder, loan terms cannot be vague or informal. A properly drafted and signed loan agreement is essential. This agreement should clearly set out the principal amount, interest rate and calculation method, repayment schedule, loan term, and any relevant conditions. Clear documentation protects both the company and the shareholder, particularly during audits, disputes, or changes in ownership. It also becomes a practical requirement, as banks typically need this agreement to open and manage a designated foreign loan account. This next point is technical, but critical. Foreign shareholder loans must be disbursed into, and repaid through, a designated foreign loan account opened in Vietnam. Using ordinary operating accounts or making off-system payments can result in transactions being treated as non-compliant. That can lead to blocked transfers, audit questions, and complications when repaying interest or principal abroad. Setting up the correct account from the start, and using it consistently, helps avoid these issues entirely. Finally, it's important to think beyond the initial loan term. What happens if the company cannot repay the loan on time? Will the parties agree to extend the loan? Is conversion to equity a possible future option? Or will the shareholders seek repayment or enforcement? Each of these scenarios carries different legal requirements. Loan extensions generally need to be registered. Loan to equity conversions require additional approvals and filings. Building flexibility into the loan structure from the beginning makes it much easier to adapt when business conditions change. At LTS Law Firm, we help foreign invested companies structure shareholder loans in a way that is both practical and fully compliant. Our team supports clients with legal structuring, drafting and reviewing loan agreements, assessing registration requirements, setting up compliant banking channels, and advising on extensions, conversions, and tax considerations. The goal is simple: secure the funding you need without creating legal exposure later. If you're thinking about borrowing from a foreign shareholder, or if funds have already been received and you're unsure whether everything was done correctly, now is the right time to review your structure. Contact LTS Law Firm for a clear assessment and practical guidance tailored to your situation. Visit www.lts.com.vn or reach out to our legal team for a one-on-one consultation. Getting funding from within your own network is smart. Making sure it's legally solid, that's even smarter.